thank you everybody for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC, and today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series. We are doing at least 2 webinars a month on different topics related to immigration law. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will send everyone a comprehensive visa guide to all the visa categories that we will be speaking about today. We will also send you a link that you can follow to sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button on our YouTube channel as we regularly upload immigration law related videos. Finally, we'll send you a link that you can follow, that you can set up a consultation with one of our experienced attorneys should you wish to discuss your case further. So today we are very lucky to have Kelly Weiner, who is the managing partner of the firm with a wealth of experience handling cases in all the visa categories that we will be speaking about today, who will be presenting about these various options available to extraordinary ability individuals and the requirements and considerations. Finally, for any questions you may have, please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jiyae. Perfect. So we're going to get started just with an overview of a few of the most well-known, categories for extraordinary ability. So one, the O-1A visa. So this is a temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. There is a high standard, which is you have to be one of the small percentage who's risen to the very top of your field. So then there's the O-1B. So this is a temporary visa for individuals with extraordinary ability in the arts. The O-1B also covers extraordinary achievement in the motion picture or television industry. So for the arts, the standard is somewhat different than the O-1A. They need to have received distinction, which means a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. So it is a lower standard than the O-1A. So sometimes if there is some flexibility in your category where it's not really clear, if it would count as O-1A or O-1B, sometimes there is, it can be favorable to try for O-1B instead if there's, since the standard's a bit lower. And then there's a different standard for the motion picture and television industry. So this is where the applicant needs to be prepared to show they've reached a level of acclaim substantially above that of their peers. Then we have the EB-1A green card. So the O-1A and the O-1B visa are temporary visas. They're for people who want to come to the United States, maybe work for, even a few months or maybe a few years, and then depart. For the EB-1A green card, this is for people who want to live and work in the United States full-time, where they have the U.S. as their main domicile. And so for the EB-1A, this is for individuals with extraordinary ability in sciences, arts, education, business, or athletics. So there's not kind of 2 categories the way there is for arts and then sciences, education, business, and athletics. This is all combined for the EB-1A. And the standard for the EB-1A is that you have to be one of the small percentage of people who've risen to the very top of your field of endeavor. You have sustained national or international acclaim, and achievements have been recognized in your field of expertise. And as well, that you need to show you're going to continue working in your area of extraordinary ability in the United States. So if you've had a really illustrious career and now you want to retire and not work in your area of expertise anymore, the EB-1A would not work for that because you do have to demonstrate to the government you'll continue to work in this area, after you receive your green card. Doesn't mean you could never retire, but if your entire plan is to stop working and come to the U.S., that would not work. So We'll talk a little bit more about this later, but even though, the standards will look very similar between, the O visa and the EB-1A, it is significantly more difficult to get a green card in this category than it is to get the temporary visas. So just because you qualify for the temporary visa does not necessarily mean you'll qualify for the green card right away. It could be something where perhaps you work a little bit more, build up your profile, and then eventually apply for the EB-1A. All right, let's dig a little bit more into the O-1A visa. So for this visa, you have to demonstrate either that you have received a major internationally recognized award, for example, a Nobel Prize, a Pulitzer Prize, or much more commonly, of course, people will qualify by showing that they meet, at least 3 of the following criteria. So internationally, or nationally recognized prizes or awards, memberships in associations which require outstanding achievements, publish material about you in major trade publications or major media about you and your work in the field, original contributions of major significance in your field, authorship of scholarly articles in professional journals, high salary compared to others in your field, participation on a panel or individually as a judge of the work of others, employment in a critical or essential capacity for organizations that have a distinguished reputation. Additionally, if none of these are relevant in your field for some reason, or maybe, you can also potentially use other comparable evidence, but to do so, you have to kind of show why in your industry you don't have proof of some of these others. And you would still need to have at least 3. So I think it's important to think about, whether or not you have each of these things, like maybe you're a member of an association, but does that association require an outstanding achievement of its members? So just meeting the plain language of the, the regulatory criteria often isn't enough. So it's really not enough that if you've received a prize or award, you have to show also that it's nationally or internationally recognized. So not every piece of evidence would be, helpful for your application. For example, if you're in a university and you won kind of, best GPA or, best student contribution, those types of things are essentially discounted by the government. They do not consider these to be helpful. Whereas potentially, let's say while you were a student, you won an award that was recognized in the industry in which, people who were not students were also, submitting, and it's not a student specific award, that could be included. The fact that you won it while you were a student does not mean it shouldn't be included. But when you think about, things that you did as part of your university community, those are often not viewed as favorably, and sometimes, better to keep weaker evidence out of the application as opposed to including, more documents. But then when the government looks at the application in totality, if there's weak evidence in there, they may feel that it drags the rest of the application down. So you do want to be, thoughtful about what you're including, work with your attorney to figure out what is going to be most favorable, for this application. All right, so for the O-1B visa, you'll see it follows a similar structure to the O-1A, where either you show that you have received a significant, national or international award in your industry, an Emmy, an Oscar, or evidence of at least 3 of the following. And as you can see, these criteria are, much more focused on what would be relevant for people in the arts. And, for people in the arts, this can take a lot, for example, you could have, designers, visual artists, things like that. So sometimes you do have to get creative about, what will count as, a lead starring or critical role, as you kind of put together these applications. So I won't kind of read out each of these criteria, but you will get the PowerPoint afterwards. And essentially very similar approach to the O-1A, where you want to include evidence that, shows that in the totality of the circumstances, you are somebody who has this, you've achieved this distinction in the arts, and meet this, this standard. All right, so let's talk about some of the differences between O-1A and O-1B. So as we've, described in previous slides, the fields are different. So, and then again, there may be certain fields where it's not that clear. For example, bartenders, tattoo artists, sometimes, Some of these, categories can be malleable and potentially fall under, one or the other. So, if you're in a situation where you do potentially have a choice, it may be a good idea to try to go for O-1B to have that lesser standard. Um, the standard for the O-1A will be, more difficult to meet since it's one of a small percentage who's risen to the very top of their field, as opposed to distinction for the arts. And then for motion picture and television, it's separate. It's a level of acclaim substantially above that of your peers. They are issued for the same length of time. So you can get an initial approval for 3 years, and then you can get an extension for 1 year if what you're doing is continuing or finishing up the same project or set of projects. If you're able to argue that you are engaging in a new set of projects, you have a new itinerary of things to do, sometimes you can have the government issue another 3-year approval. If you're changing employers, you're changing agents, you can also, apply for more than, for 3 more years, as opposed to just getting the 1-year approvals. And you can continue to get these renewed indefinitely. There's not a limit on the amount of years you can spend in the US on the O, the way that for an H or an L, you're limited at a certain point. But for the O, you don't have that concern. You could keep extending it for as long as you have, extraordinary ability work available to you in the United States. And your family is able to come to the US with you. They can get O3 visas. This would include your spouse and any unmarried children under 21. Your spouse is not able to work, though. So your children and your spouse, while they're in the US, could attend school, but would not be able to work. So if your spouse wanted to work, they would need to get their own independent, work visa based on their own, background or employer sponsorship. All right, let's talk about the EB-1A green card. So the requirements, the listed requirements and the regulations are very similar to what's on the previous slides for the O-1A and the O-1B. So it's the same structure, either receipt of a major award or meeting 3 out of, the listed criteria. So something to consider is that you will need to show, they'll do 2 steps, and this is based on something called the Kazarian analysis. So the first step is, have you met each of the criteria? Have you included evidence for at least 3 of the criteria or the major award? Ideally, you'll have more than 3. 3 is the minimum, and you don't need to have more than 3, but better if you do. Certainly the weight of the evidence would, be more compelling if you do have more. And then in that second step, so for example, if you said, I have prizes, I have, memberships, I've judged, on panels, they'll look at all of that. And then in the second step, they're going to consider the quality of the evidence in totality. So like, does this show us that this person is someone who's risen to the very top of their field of expertise? Are the memberships ones where there's other, very high profile, prestigious people from the industry? Is it one where instead of just paying a fee to become a member of an association, you actually have to, be asked, based on accomplishments, in your industry? So those types of things are very important. And as part of your application, it's always important to highlight, if you say, hey, I published in this journal, you also need to explain why is that journal impressive? Why is that journal prestigious? What are the circulation figures? And if circulation isn't very high, is it because, it's a very niche, industry? So you do want to kind of be thoughtful about all the information that you're providing and think about how you can communicate to the government that, the weight of this shows that you are someone who's risen to the very top of your field. And this can be especially tricky or important, when you have a field that is not as much in the mainstream, so there's not kind of, sometimes it can be helpful to really define the field, explain to the government, what are considered markers of success in this field. If it's something where you're often working behind the scenes, you may need to do a little bit more to explain, hey, even though, my name is not like the one on the front, of this project, I'm still, somebody who should be, credited with, the success. So that can be kind of a nuanced argument to make, but is important, in demonstrating to the government that in totality, you are someone who's risen to the very top of your field. All right, so now we're going to switch gears a little bit and talk about the National Interest Waiver, which, while it's not an extraordinary ability visa, does share some characteristics of an extraordinary ability, visa application. And Jiyae will guide us through that part of the presentation.
Thank you, Kelly. Yeah, so let's talk a little bit about the EB-2 National Interest Waiver NIW visas, which can be an alternative to the EB-1A or the O-1 visas that we discussed for certain types of applicants. So it is important to emphasize that the NIW option is a green card option. And it is also important to note that the NIW is also what is called a category that allows self-petitioning, which means you don't need a job offer from the US. You don't need a US-based employer to actually sponsor you. You don't need to go through what is called a traditional labor certification process, which is required when someone is applying for a green card based on employment, based on sponsorship by a US employer. Now, however, there are some particular requirements that the applicant must meet in order to qualify for the green card under the NIW. All right, so the first question to note is, do you meet the threshold requirement to qualify under the EB-2 category itself? So the way to meet the EB-2 category is either by showing that you have an advanced degree or its equivalent, or that you have exceptional ability. And let's break that down a little bit. So advanced degree is defined as a master's degree or higher. And so, for example, if you have a JD or MD or an MBA, for example, like those degrees would qualify as a master's degree or higher. So even though, like a JD is not really a master's degree, it is considered, a master's level degree, an advanced degree, because you need to have a bachelor's in order to gain admission to that kind of program. Now, if you don't have a master's degree, you don't have a PhD, you don't have that, there is a way you can qualify with a bachelor's degree if you have 5 or more years of progressive work experience following your attainment of the bachelor's degree in your field. So what does it mean to have 5 years of progressive work experience? It means that your work experience was increasing in complexity and seniority over time. So for example, if you worked in a position after you graduated from your bachelor's and your job title stayed the same, your job duties stayed the same, your salary stayed the same, then that's going to be a weaker case to show 5 years of progressive work experience. By contrast, if your job titles change to include more senior duties, if your job duties change to include more complex tasks and more supervisory or senior level duties, if your salary has changed, increased in step with those changes, then that is a much better case to show that you have a progressive work experience in your field following your bachelor's, which is that your positions grew in complexity over time. So if you can meet the threshold requirement through showing the advanced degree, or the other way, if you either do not have the bachelor's degree, if you do not have the required work experience, you can try to qualify for the EB-2 through showing that you have exceptional ability in the sciences, arts, or business. And now, what does that mean? So holistically, the standard is that you need to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the field. And from that language, we can note that this is different from extraordinary ability, right? So the extraordinary ability, which is the standard that we just discussed for the EB-1A, for example, you need to show that you're at the very, very top of the field, one of the small percentage who have risen to the very top of their field. Exceptional ability is a lower standard than that. So they don't require you to demonstrate that level of expertise. You just need to show that you're operating at a level that is significantly above what is ordinarily encountered. Now, how do you prove that you have extraordinary ability in the sciences, arts, or business? So you should be able to present evidence that is meeting at least 3 of the 7 criteria that is written here. And for example, that includes 10 years of full-time work experience in your field, proven through, letters from previous employers, for example, describing your duties and the period of work, evidence that you command a high salary compared to your peers. That is, that is evidence of your outstanding work in the field. You can also submit recognition for your achievements, forms evidence of recognition for your achievements by your peers, from industry associations, by government actors. And this can take various forms. It can take, expert opinion letters. This can take copies of, original publications or patents that you've made, or any awards that you've won in the industry, any, media articles featuring your work showing that you have been recognized. So you can be creative with the types of evidence that could really show that you have been recognized for your exceptional achievements in your field of endeavor. So let's now move on to the other part of a NIW application, which is providing evidence that you meet the qualifications for an NIW itself. So as a reminder, you do need to both meet the EB-2 threshold and also be able to convince the government that you qualify for a national interest waiver. Now, how do you prove that? So the national interest waiver eligibility criteria is a three-pronged test that is promulgated by a case law called Matter of Denisar. And the three prongs are as follows. And you do need to provide evidence to meet all three prongs. So the first prong is that the applicant's proposed endeavor has substantial merit and national importance. And what does that mean? So substantial merit can be met in a wide variety of fields, including business, healthcare, education, science, technology, and even if an endeavor can result in broadly enhancing societal welfare, for example, or broad cultural enrichment, those types of endeavors can also qualify as endeavors of substantial merit. Endeavors that try to further human knowledge in those key areas, such as medical advances or civil engineering or manufacturing, those kinds of endeavors are also favorable to meet the substantial merit and national importance prong. Now, for national importance, what the government looks at is what is the prospective impact of the work that the applicant is proposing to do in the United States. So does the work stand to benefit only the applicant's immediate employer or immediate clients, or is the impact more broad? So is the applicant, for example, providing a new innovation in a technological area that is important for U.S. governmental interest, and will that result in, a more wholesale advancement to the field as a whole? The latter type of endeavor is what the government is focused on. So the question, another way you can meet the national importance criteria is by showing that your work will offer the United States a strong positive economic impact. All right, so really the question to ask here on meeting the first prong is, what is the future impact of the applicant's endeavor, and how is that important to the United States? And in this, in proving this prong, one thing that a lot of applicants may do is look for government reports, published by government agencies, really noting why certain areas are key to the U.S. government's strategic interests. So let's move on to the second prong then. So the applicant also needs to show that they are well positioned to advance the proposed endeavor. And what does that mean? For that, the focus is on the individual applicant. So the government will look at the individual's education, professional experience. Really, they're looking for a record of success in previous related projects that really positions the person well to continue doing that sort of work in the future, and can really show that their future work will also have an impact in the field. So you do really need to show that you have been making a similar, outsized impact in your field, or otherwise is well positioned to do so through your experience, education, and other means. The third and last prong for the NIW is to show that on balance, it would be beneficial to the United States to waive the requirements of a labor certification for that particular applicant for that particular case. And there are several ways, several strategies an applicant can do so. For example, the applicant can emphasize prong 1, which is really emphasizing the broad systemic benefits the applicant's work can have to the field as a whole. The applicant can also emphasize prong 2, really show the applicant themselves have unique know-how and experience that other U.S. workers with minimum qualifications just simply do not have. Finally, there are some special considerations that is relevant to entrepreneurs, for example, regarding substantial economic benefit to the United States. The entrepreneur applicant can talk about how their endeavor stands to create a high number of US jobs and generate substantial tax revenues. That could be a countervailing positive consideration to the ordinary requirements of labor certification. Okay, so we'll move on to the next slide. So the next topic we'd like to cover is what is included in expert opinion letters. So expert opinion letters play an important role for extraordinary ability types of petitions. And they are relevant for both O-1 petitions, EB-1A, and NIW petitions. The purpose is a little different. So for the EB-1A and O-1 petitions, you would want the experts to confirm that the applicant has extraordinary ability in the field and is well known for their outstanding achievements they have made in the past, and really confirming that they have sustained national and international acclaim in their field or is otherwise outstanding. For the NIW petitions, there can be several different types of functions that the expert letters can support. For example, certain letters can talk about the national importance of the proposed endeavor, such as a letter from a government agency or someone affiliated with a government agency. Another type of letter can really focus on the applicant's contributions to the field, which can show how they're well positioned to advance the proposed endeavor. So for example, that would be letters from previous employers confirming the applicant's leading role in a particular project that has resulted in an outsized impact to the field, such as development of a new technology. One other option for an entrepreneur who is applying for an NIW is getting a letter from an economist, really talking about the indirect and direct and, induced job creation and economic production impacts that is expected from their endeavor. And frequently for those types of applications, it may be a good idea to also include a detailed business plan talking about how the applicant would realize these particular impacts. Now, who is writing the letter? So generally, you want to get a letter from leading experts in the field who have decades of experience. You don't want to get letters who are more junior than you. You do want to get letters who are at least on your peer level or senior level than you. And in those applications, we do add the expert's full curriculum vitae, which really shows that they are leading and that they have been recognized as someone who can give an informed opinion about someone's status in the field. So yeah, you're really looking for people who are serving in senior positions in leading institutions in your field, CEO level, executive level, professors in a particular area who have lots of citations, lots of publication history, really looking for peer leaders in your industry. Now, a particular interest for an NIW application is if you can get a letter of support from a government agency, whether it is a federal level government agency, a congressperson, or a local level government agency, such as city level or regional level. Any and all letters from a relevant government agency from your field could be a favorable addition to your petition on proving the national importance of your endeavor, whether you're well positioned to, advance your endeavor, or that on balance, it is beneficial to the United States to approve the NIW for you. So government agencies could be a very favorable addition in the NIW context. How does the individual know you? So it is recommended to really have a mix of independent experts and inner circle experts in a petition. And inner circle experts are people who have worked with you and can speak to your achievements in the past. Independent experts are people who have not directly worked with you, but know you through your work or through your reputation in the industry. And those letters can confirm in an objective way how your abilities are outstanding in your field or how that your work stands to impact the field in a significant way. So what is the content of those letters, right? So it is very important to include specific details and specific discussion in the letters regarding your work, the recognition and accomplishments and achievements. And letters that are usually formulaic and simply, have hyperbolic language or simply repeat the regulatory requirements are not persuasive. Really, you want to get at specific details on how does your work set you apart from others? Why are your achievements important? How is what you do different from what is, normally done in the field? So it is very important to, elicit as much specific information as possible to include in those letters, to really give the USCIS officers a concrete picture of what you're doing that is, set apart from others. All right, so we'll move on to the next slide. Which category should I apply for? So there is some strategy in, choosing between the various visa categories that we have been discussing so far. And the first question you want to ask yourself is, do I want to stay in the United States temporarily or permanently? So as Kelly mentioned earlier, the O-1A, O-1B are non-immigrant visas, which are well suited for people who want to come to the United States to work on a temporary basis. Although it is true that you can continue to extend the O-1A, O-1B as long as you continue to have work in the United States relating to your area of extraordinary ability, there is really no 6-year limit or 7-year limit that other types of visas have. So one thing to note is that if you have a need to travel in and out frequently, and if you also, if you expect that you may want to spend, a lengthy amount of time outside of the United States, for example, the O-1A, O-1B could be good options for you because the EB-1A and NIW, they're green card categories, and they have certain restrictions on how long you can stay outside the United States at a time. So turning over to EB-1A and NIW, they are green card categories, and really they are well suited for people who want to live in the United States permanently. And also the EB-1A and NIW green cards eventually can lead to citizenship after 5 years of living in the United States and other requirements. So if citizenship is one of your goals, the EB-1A and NIW could be great choices for you. Now, the other questions you want to ask yourself is, do you have a US employer or agent, or do you want to self-petition? So the O-1A and O-1B non-immigrant visas do require a US employer or agent to act as the petitioner of the case. Now, it is possible if you are an entrepreneur and if you set up your own company in the United States, that US company could act as the petitioner because that US entity that you set up, even if you own it, is considered a separate legal entity from yourself, the foreign person. So that may be one option that you may take. However, that connection is necessary, and the person cannot self-petition for an O-1A or O-1B visa. Now, the EB-1A and NIW are both green card categories that allow self-petition. That means you do not need a US-based petitioner. You do not need a US-based agent. The foreign national themselves can act as the petitioner for the case itself. Family considerations. So as Kelly mentioned earlier, for the O-1A, O-1B visas, your spouse and minor children, unmarried, under 21, can come to the United States with you as O3 dependents, and O3 dependents can go to school in the United States. However, there is no work authorization available for an O3 spouse. By contrast with that, the EB-1A and NIW, both green card options. Also, your dependents can get your green card, get their own green cards alongside you if they join you on their petition. So that means your spouse and children under 21 can apply for green cards themselves as dependents alongside your application. And if you're applying to adjust status in the United States through filing an I-485, your spouse and children can also file their I-485s alongside you and can also apply for work authorization and travel authorization for the spouse when they also file their I-485s with you. So this can be a significant advantage for certain people. All right, so now let's shift gears a little bit and talk about the considerations when you are considering moving from a non-immigrant visa to a green card. So the first issue to consider is qualifications. As Kelly mentioned earlier in previous slides, the EB-1A carries a higher standard for eligibility as opposed to the O-1A or O-1B, even though the regulatory language is very similar. That means qualifying for an O-1A or O-1B does not automatically mean that you also qualify for an EB-1A green card. Particularly, jumping from an O-1B to an EB-1A could be a little bit more challenging because the O-1B only requires distinction in the field, whereas the EB-1A requires that you show that you have sustained national or international acclaim in your field. So there really is a different level of evidence that each category requires. So this may mean that you just need to work on your profile a little more, gather a little bit more stronger evidence that can support an EB-1A standard as opposed to the O-1B standard. Timing is another issue. So consider how much time is left on your current underlying visa, right? So if you are already on a non-immigrant visa, and if you need to renew your non-immigrant visa soon, it could be prudent to wait before filing your immigrant petition, I-140, if you're, planning on filing an EB-1A or an NIW application. Those are immigrant petitions. Because filing an immigrant visa may act as evidence of immigrant intent, which could be one of the concerns that may come up at the visa interview or at the border if you are applying to renew certain categories of visa, such as a TN visa, for example, which really strictly looks at non-immigrant intent. So definitely important to note that some visas are harder to extend or subject to more scrutiny once you have applied for an EB-1A or an NIW application. Dual intent visas are not affected by this, and this applies to the H-1B and L-1, and O-1 also, you can also apply even if you have an I-140 filed. That will not mean that your application to renew or extend will be denied. Now, the last question you want to think about is family, right? So if you have children who also need the green card, it could be very important to consider filing early enough to avoid issues with a child aging out at 21. That is a very important threshold. So that could be a consideration of when you decide when to file for the EB-1A or the NIW petition. All right, so we'll move on to the next slide. Are extraordinary ability categories available for entrepreneurs? And the answer to this question is yes. EB-1A and the NIW are categories that both allow for self-petitioning, as I mentioned earlier, meaning that both are possible options for entrepreneurs. You do not need a U.S. job offer or sponsorship from a U.S. company in order to apply for EB-1A or NIW. The second point to note is that there were changes in the national interest waiver adjudication standard under the matter of Denisar, which is a case that came down in 2016, which made NIW a much friendlier category for entrepreneurs. And we've even had specific policy updates in 2022, where the government outlines certain types of special evidence that entrepreneurs can rely on to, support the merits of their case, such as, history of job creation, history of revenue growth, for example, a high valuation, agreements for investment. Those are certain things that entrepreneur candidates can present to support the merits and importance of their case. The third thing to note is that an O-1A could be an option for an entrepreneur, although it is needed to have a separate U.S. corporate entity that can act as the petitioner. It is still not possible for a foreign national to self-petition for an O-1A visa. However, if the entrepreneur sets up a company in the United States, that company can act as a petitioner to drive forward the O-1A petition, and that could be an option for those people. All right, so I believe that is all that we had as prepared. We can go through the Q&A. I guess I can take the first question. Is a master's degree from Canada considered equivalent? What types of documents are needed to demonstrate if considered equivalent? So if you have a master's degree from Canada, yeah, you would just need a what is called an educational equivalency report from an accredited agency that can confirm that the master's degree is equivalent to a U.S. master's degree. And so you would want to, prepare the proof of that Canadian master's degree that you have alongside the educational equivalency report that you get that confirms that your degree is equivalent to a U.S. master's degree. I can also take the next one. I'm not going to go too deeply into the specific facts, but I'll see if there's any general insights I can share. Yeah, so if you are a second-year PhD student and you do have a master's before, so if you have a master's degree from a foreign country, definitely get the U.S. equivalency report to see if it is a equivalent master's degree. And if you do that, then you will qualify for the threshold, EB-2 threshold of being an advanced degree professional. But the more important thing is, do you qualify for the NIW 3-pronged DANISR test, which requires the applicant to show, that their proposed endeavor is, has substantial merit and national importance, that you're well positioned to advance the endeavor, and that on balance, it is beneficial for the United States to, exempt you from the labor certification requirement. And that one is a more fact-specific inquiry. I definitely go ahead and schedule a consultation with us. We'll be happy to look at your case and provide our, opinions. All right, bachelor's and master's degree from UK from a recognized university. Do I need to evaluate both degrees or only master's for the EB-2 NIW? So if you are relying on the master's degree as the relevant degree for your proposed endeavor, then you can go ahead with just evaluating your master's degree. It is not necessary to show 2 degrees to meet the EB-2 threshold. It may be prudent to include the bachelor's degree to show that you have, a history of education in your field. But yeah, in order to just meet the EB-2 threshold, the master's degree should be sufficient if it is judged equivalent to a U.S. master's degree. NIWs for pilots, definitely schedule a consultation with us to discuss that. It is a very complicated area, very nuanced. So we will be happy to discuss your case once we have a more detailed knowledge of the facts. On O-1B visa, Kelly, do you want to take that?
Sure, yeah. So it's talking about kind of shifting work fields, like if you're a dancer and you have extraordinary ability or distinction in the field, and now you want to work in a different field. The examples given are choreographer or costume designer. So if you do want to change your field, you would need to independently qualify for extraordinary ability under that field. So you would need to show that you had extraordinary ability as a choreographer or as a costume designer. So it would be a separate, different application, and you wouldn't be able to kind of just change it while you were on the O-1B you were already granted. When it's granted for the extraordinary ability, that you demonstrate in that petition.
All right, it seems like we have answered all of the questions that came up. Thank you, everyone, for your active participation. How to schedule a consultation?
Yeah. So you can do that on our website if you Google Scott Legal, and there's several buttons that will take you to schedule a consultation.
All right. Look forward to connecting. And yeah, hope everyone has a great day. Kelly, thank you for sharing your expertise, and thank you, everyone, for your participation today.
Thank you.